York, we have something called a summary jury trial, and it can be done in one day. You pick a jury, and the judge will usually limit your time to pick a jury. So they might only give you 15 minutes for what's known as voir dire or jury selection, where you talk to a group of people, like 20 people, and then you pick the 6 people that will be your jurors along with 2 alternates. You get to speak to them as the plaintiff's attorney, and of course, the defense attorney gets to speak with them as well. Next, the judge will start the trial. So they will assign a judge, you'll go into a courtroom with your jurors, and the judge will set strict time limits. So you will have 10 minutes for an opening statement, and you will have usually 10 minutes for the closing, which is the summation at the end. And in the middle, you are going to be able to call your client to the stand, and that is going to be part of your case in chief. And that is usually limited to 1 hour or less. And you will question your client, and your client will say what happened. A lot of these cases are car accident cases, right? And if there's an issue of liability, meaning who is at fault, the client will testify, and they'll talk about how the accident happened, why they were safe, seeing what there is to be seen, driving safely, and how the defendant did something negligent, like either was speeding or changed lanes or disregarded a stop sign or a red light and crashed into them. And then the plaintiff will also have to testify about all their injuries, right, and all their damages and how this has affected their life, tell some stories about it. They can even call witnesses, or maybe do a witness that's been recorded and played, but it has to be short because your entire case in chief is limited to 1 hour. And then what happens is a defense lawyer for the insurance company will cross-examine your client. That time is not counted against you because that's their cross-examination. And if there is a liability issue, the defense lawyer will then call their driver, and then you get to they give direct testimony to their lawyer, and then you get to cross-examine them. And then after that, you get to do what's known as a medical presentation. Because it's a summary jury trial and it's done in one day, you don't call doctors. The whole purpose of it is to save time and to save money. So calling a doctor, for example, to come to court, they would have to leave their practice. If it's a surgeon, they might charge you $10,000 to come to court because they'll have to be there in court all day answering your questions. And then the insurance company will start cross-examining them, which could take, it could even lead them to come back the next day, and then they'll charge you $20,000, right? So the whole point is you don't do it. So here what you do is you submit your medical records, and these are medical records for your client, and you submit an evidentiary package. It's basically the evidence. Your medical records, you can create timelines, you can use PowerPoints or illustrations. You can get creative, you can bring in models of like the spine or body parts that were injured. And what happens is you get to play doctor as a lawyer, and you get to explain everything. And usually that is limited to about 20 minutes. Like I said, it's an hour for everything. So usually it's like 20 minutes for the direct of your client, the direct examination when your client is testifying, 20 minutes for the medical presentation, and then I believe you get 10 and 10 for the opening and the closing. So that's another 20. So that's all together, it adds up to an hour. Sometimes judges, depending on the judge, will give you a little bit of leeway, but they want to give the jurors time to deliberate. They want to usually be done by about 2 p.m., and then the judge has to charge the jury. That's known as reading all the jury instructions to the jury, and then the questions that they will have to answer. Usually the questions are things like, was the defendant negligent? Was the defendant's negligence a substantial factor or a cause of the crash? And then if they answer yes, that they were negligent and it caused the crash, then what is an amount that we should allow for to the plaintiff for past pain and suffering, and just all of their damages, right? And then future pain and suffering and all of their damages. And the way they calculate future is they look at their age, and there are life expectancy tables. So somebody who's older may only live for like 10 years, and they put that right into the question. Somebody who's younger in their 20s may live for 50 more years, and they put that right into the question. So the jurors are kind of oriented to how many more years of future damages they should allow for. So that's how they do it with these summary jury trials. And in closing, it's good to actually have the slides up there of the question. So you'll say, hey, this is the question. When you guys go back there, you have to talk to each other. This is the question that you're going to have to answer, and this is how I suggest that you answer it. And you say yes, no, whatever you want them to say, and then how much because people aren't going to know, right? These are just people from the community. Some maybe have done jury duty before, but they might have done it in a criminal case. They may have no idea what a civil case is. So you want to tell them, hey, civil justice in this case is $100,000. And then you have to also be mindful about the types of cases that you do a summary jury trial on. Usually, I like to limit them to smaller cases, cases that are worth $100,000 or less. If you have a $100,000 insurance policy, and for whatever reason the insurance company is being cheap, they're offering you like 15 or 20, where you think it's worth 100, go ahead and do a summary jury trial, because you could get a verdict of more than 100, but then you'll still be limited to the 100. That's one of the stipulations and then sometimes you'll also be able to get something on the low. So say, for example, you do the trial and the jury says, you know what, the defendant was not negligent. And then it's known as a defense verdict. You get 0. Well, if you negotiated a low parameter, you still get that 15,000 or 20,000 or whatever was your low. So that's always something you can do to protect the client on the downside. But then you have the upside of the entire policy. So it's good to do it with smaller cases. Some examples of summary jury trials that we did involved one in the Bronx we had, where a gentleman was driving, he got rear-ended. It was a really minor rear-end impact. I believe the property damage was like less than $500, but he did have some injuries. And so the insurance company was offering us like $20,000, and the policy, I think in that case, actually the policy was bigger. It was one of the ones we did where the policy was bigger. It was a $200,000 policy, and I believe the verdict that we got was a little bit over $200,000. So we were able to take pretty much close to the entire policy, if not the entire policy, which was a good result, because that case was, like I said, it was very tough. It was a very minor property damage. So a real trial, a full trial, you might spend like $10,000 on that doctor, $20,000 on that doctor, and then you never know. The jury could say, you know what, I'm not going to give anything because I believe it was just a little fender bender, and then you're out of luck. You get nothing. We had something on the low. I think we had $20,000 on the low, but it ended up being a good result. Another one we had was in Brooklyn, where there was a clavicle fracture, and originally the driver was contesting liability, saying our client was on a bicycle, that he darted out. But then when the trial happened that day, the defendant just didn't show up, and the defense lawyer said, look, I'm going to concede liability, but I'm going to say it's still worth only $20,000. I don't know why all these insurance companies think everything is worth $20,000, but they said it's not worth anything. It healed. But, I presented the case. I explained that it did heal, but it left some residuals. It was actually slightly comminuted, meaning it got shattered into pieces, and we were able to recover, I believe, $135,000 on that case, because it had a lost wages component. It also had the pain and suffering, and so the policy was 100. So the fact that we got 135 meant that we got the entire 100 for the client. And then another one that we did actually during the pandemic, during March of 2021 in Brooklyn. There we had 2 clients, and they had pain management, like epidural steroid injections. One of them, I believe, had a percutaneous discectomy, and we had some offers. The offers were not unreasonable, and that one actually, I believe, was something that we keep learning. That this is why they call it the practice of law. That one, I believe, had a larger policy because it was 2 different people. So usually the way the policies are written is like, let's say it's 100, 300. That means it's 100 per person, but for the entire accident, you can get up to 300. And so in that case, I believe the offers were something like 75 for one and 100 for the other. And at the end of the trial, that's around where the jury came back. I believe the total was something like about $150,000 for both. And so one of the reasons I think we weren't able to get more was because the judge in that case, for whatever reason, was really upset. She was just in a pissed off mood that day, and she just really gets 5 minutes and sit down. You can't give a closing for more than 5 minutes. You can't give an opening, and just basically limited us, wouldn't let us use models, demonstrative, nothing. And one of the reasons was, she said, well, this is just a summary jury trial. So in many ways, a lot of the judges, or perhaps some of the people in the court system, kind of denigrate the summary jury trial. Oh, it's just a summary jury trial. Who cares? So in that sense, that's why I'm saying I would learn my lesson. Now I would never do it on a smaller case like that. Even though, whatever the settlement offer was before was more or less comparable to the verdict. but I felt like if we had done a full trial on that case, perhaps we would have had a better shot to really get that full policy and get more, which could have been double what the verdict was and could have been much better for the client. So that's something as a lawyer, you always have to keep track of what's happening and, always be learning and always be improving. That's why they call it the practice of law. So that's something we strive to do. And we also have to be vulnerable. Look, sometimes we make mistakes. And in that case, I think it was a mistake. It was just a strategic mistake to do a summary jury trial. Maybe also during the pandemic, everybody was in a mask. It was March of 2021. The courthouse was empty. We were like the only people in the courthouse. But for whatever reason, the judge was, I don't know if she was, and I saw that judge a few weeks later, actually on a Zoom, on a virtual hearing, and she was so pleasant. Maybe she was just having a bad day that day. No, we don't know. But anyway, that was like a case where I think a summary jury trial did not help us. But usually, like I said, it could be helpful, especially on the smaller cases, the 100 policies, the cases, the $25,000 insurance policies, which we have a lot of in New York, the $50,000 insurance policies, the soft tissue cases. There's a lot of soft tissue cases where there's no epidural injection, there's no percutaneous discectomy, there's nothing, right, other than like going to a doctor, chiropractor, getting adjustments, and just doing physical therapy, stretching, maybe things at home, things at the doctor's office. Those kind of cases, if you have a fair offer, you could settle them. But a lot of the time, the insurance company will just say, I'll give you $5,000, I'll give you $7,500. And then, that kind of case, even if you have a bigger policy, let's say you have a $250,000 policy with one of those soft tissue cases, right? No surgery, all soft, right? You could take a shot. What are they going to give you? They're going to give you 10 or 15,000. So you could say, no, thank you, file a lawsuit, do depositions, put it on the trial calendar, and then do a summary jury trial, come in there with all the evidence. And then, you could hit on a case like that easily for 150, maybe even 200,000 on a soft tissue case with no surgery and with no, with nothing else. And then you've done great because the client originally would have only gotten, let's say, 10,000 after legal fees and expenses. That's like 6,000 in their pocket. If you hit for 200, you're talking about the client getting about 130,000 in their pocket. So that's 6,000 versus 130,000. That's like more than 20 times. So it really makes sense to do it in that kind of situation. So I hope this has been helpful, but this is how you can do an entire trial in one day. And the other good thing about it is that you don't have to wait usually as long as you would. Like right now with the pandemic, a lot of people are waiting years and years to get a trial date. They're just on the calendar, kind of like in line waiting, not knowing when their turn will come. But with a summary jury trial, if both sides say they agree to a summary jury trial, usually the court will schedule it fairly quickly, maybe within a few months. So like I said, we had one actually for April 20th, and it's going to get adjourned. It's going to be in mid-May, but it should go, and it should be pretty simple. It's a pretty straightforward case, so I'm looking forward to it. We're preparing with the client. We got everything lined up. So I'll let you know how that goes. And then we have a few others, summary jury trials, as well as full trials this summer. So we're getting ready for them. Okay, have a great day, everyone. Talk to you soon. And let us know what questions you have.